Thanks, and thank you everyone who survived till now. This is the last paper before lunch, so please bear with me. For those new to conferences, there is always a joke about papers before lunch, but I'm not very good at them, so I'm not going to really do it. But just you can imagine that I did it. So this is a chapter I've been working with Estelle. It's not been published yet, so any kind of ideas that you may have may be incorporated in the final draft. So please do share it. I welcome kind of a critical thoughts on that. This is the overview of talk. I'm going to say what's the premise of it, the thesis and the main research question. I'm going to present 3 meanings of data sustainability. I'm going to focus on probably the most boring of intellectual property rights, that is called sui generis right or database right. I know I lost half of the room after saying that, but it's the truth. And then I'm gonna sort of look into one of the most recent sort of element of the European data strategy. There is the Data Act. One of the things that the Data Act does or will do at some point is to amend the database directive. And so the question is whether it's gonna change it in a sustainable way or not. Premise number 1 is that we don't need incentives to produce more data. Data is being produced. I think Professor Webster was very clear about the dimension of big data. So clearly we don't need incentives to create more data. Premise number 2 is that we need to have access and reuse of data if we want to achieve some societal goals, including the UN Sustainable Development Goals. And the third premise is that in the 4th Industrial Revolution, and more generally in highly technological contexts, data is increasingly enclosed, closed as opposed to open, enclosed by legal and technological means. And when I say legal, I mean mainly intellectual property and contracts, but not just that. So the thesis is that we need to find incentives to push private companies to open up data rather than enclose it if we want to achieve the sustainability goals. The context of this research is essentially a conversation with Estelle where we were thinking, there have been changes in the law and in practice to sort of push governments and public entities to open up their data. And again, it's something that Professor Webster underlined. At the same time, for example, the Open Data Directive, the new Open Data Directive, at the same time, also citizens are being encouraged to open up their data. And probably the main example would be the concept of data altruism in the Data Governance Act. So we feel that not enough is being done to actually push and nudge and maybe force private companies to open up their data rather than creating these data monopolies and privatization of data. With this in mind, the research question is, how can the law incentivize private companies to allow access to and reuse of big machine data produced by IoT and other 4th Industrial Revolution technologies? I'm going to focus on the database right or sui generis right. I'm not going to consider copyright, and I'm not going to consider privacy because better lawyers have discussed that already. So starting with the concept of data sustainability, I suppose as innovation lawyers, if we want to use that expression, we've started only recently to deal with concepts with the idea of sustainability, which was traditionally the domain of environmental lawyers. But I think as a research agenda, it's really important that we try and do a little bit more in this direction. There is quite a basic meaning of data sustainability that is essentially the data used to measure the progress in pursuing the UN Sustainable Development Goals. Probably the most famous example is the Open SDG Data Hub that you can use to track this type of progress. A second meaning is the use of data, not to track progress, but to actually develop, invent, and deploy new data-driven smart solution for a more sustainable future. So essentially, you like smart technologies, blockchain or whatever, with some sort of applied in a context of, for example, water, improving clean water and sanitation. For example, if we use sensors connected to water pumps to track access to clean water, or for example, if we use mobile phones and GPS to help predict the spread of infectious diseases. These are just two examples where we are using data-driven technologies to pursue the sustainable development goals. But you can find really hundreds of that. And then there is a third meaning of data sustainability that it's much, much broader, and probably it's something that everybody in this room is more familiar with. That is the idea that if we keep using, processing, reusing data in the way that the way we are using and reusing data right now is unsustainable, that we cannot keep doing the things the way we have been doing it. So the idea of unsustainable data practices, use of big data to accentuate inequalities, algorithmic bias, digital discrimination, predictive policing, commodification of emotions, and digital dispossession, this idea that in theory you have control over your data, but obviously these private companies are amassing large amounts of data, including biometric data, and keeping firm control over them, regardless of the GDPR that many may be surprised, but it's not a savior, or not all the time at least. So the focus, again, it's quite narrow in this presentation, is about the database right, or sui generis right, or sui generis right, depending on your pronunciation. That's something that was introduced by the database directive, or Macarena directive, because it was passed when everybody was dancing the Macarena back in 1996. That was the man Lamberto Dini who signed the directive. So that kind of gives you a sense of how old this piece of legislation is, nearly as old as Lamberto Dini. But that doesn't mean that it's not necessarily something cannot work today. We have to think about that. The database right, or sui generis right, is the right to prevent extraction or reutilization of the contents of a database. So it's a particular type of IP right. Some say it's not a proper IP right. And the concept of database is really very broad, because it's the collection of data arranged in a systematic way, and they are data that is individually accessible. So for example, all the data that has to be kind of organized and structured, for example, all the recordings that Amazon collects about your voice when you use Echo or other Alexa-enabled devices, that could be regarded as a database. And if that's the case, that means that does Amazon own your recordings? Not clear, but potentially. Nobody likes the sui generis right. Everybody hates it except me. And mainly everybody hates it because it's regarded as a form of monopoly in the collection of facts, and as such as is anti-competitive. But I think we should save it. Save it from who or from what? The sui generis right has been killed, or nearly killed, by the Court of Justice in 2004, where the Court of Justice, the British horse racing cases, essentially creates a dichotomy that is not based in the law as such, but they believe that it's an important dichotomy between newly created data and obtained data. So if you are investing in obtaining data that already exists, you're obtaining it, then that attracts protection. Whereas if you're investing in creating new data, then that data is not protected under the database right. So this obtaining, creating dichotomy. The application of this dichotomy to machine data, to IoT data, the prevalent application is that all machine data is data that is created and as such not protected by the sui generis rights, which most people think it's a great thing, because if it's not protected by the sui generis right, it means that it's free for all. It's not, it's not owned by these private companies. Wrong. This dichotomy between creating data and obtaining data is a little bit untenable, I think. You can see, examples already in the past, for example, football data, live football data that were regarded as obtained in the UK and as created in Germany. So it wasn't obviously clear, where live football data was. What about, for example, use AI applications that are used to sort of identify links between existing data? Is that newly created data, or is it obtained data? What about sensor data about facts of nature? Are we creating new data, or are we obtaining new data? It's not really clear. So why do I want to save this sui generis right that is very near its death? It's probably the main reason can be found in the PR Aviation versus Ryanair case that some of you probably may remember. This case is about web scraping, the use by this company PR Aviation of data taken from Ryanair's website. Like when you have to use data about, for example, the cost of flights, or when the flights are, etc., etc. And that was against the terms and conditions of the website Ryanair. But that was something that arguably was allowed under fair use, if you want to say that, one of the exceptions under the database directive. However, what the Court of Justice found in this case was that because we are outside of the scope of the database directive, because one of the requirements for protection doesn't apply, then the exceptions don't apply as well. The end result is that you can use terms and conditions to protect, own, control data, regardless of those limitations and exceptions that are enshrined in the law, in this case, in the database directive. And this is one of the most important problems, I think, that we have today. The use, what many people call private ordering. The idea that in all the gaps that are left by the law, that's where you find private ordering. That's where you find private companies setting their own rules by means of technological measures, by means of contracts, informal standardization processes, etc., etc. So how do we stop that? Because obviously, if the database sort of right dies in the way that it seems that it's dying, then we seem to have little protection against these forms of private ordering, these use of contracts and technologies to effectively control and monopolize our data. Does the Data Act provide an answer to this? So the Data Act, again, the latest invention of the European Commission, the latest instance of the actification of EU law, was introduced a couple of months ago. The purpose is to, one of the objectives of this act is to facilitate access to data and reuse of data. So you are using your smart devices, you're producing data, you should be entitled to have access to that data and to share that data with, for example, other companies. And that in principle is an important thing, because that data can be then reused for good. The assumption of the Data Act is that big data is mostly underused, which could be accepted as an assumption, not maybe critically, but and that if we used all the data that we have, we would be able to fight for climate justice and achieve a sustainable data economy. But at the moment, we cannot do that because we cannot access all this beautiful big data. The way to achieve these beautiful goals is to introduce new individual rights that we've seen how well they work so far. The right of users to access and use data generated by the smart products and to share it with other companies. But also it's done by amending the database directive, and that's where I kind of want to focus in the rest of this talk. There is only one provision, one binding provision in the database, in the Data Act about the database directive. That seems pretty straightforward. So you may think, oh yes, for once the lawmaker has been clear, we have no problems at all, because it says the sui generis right provided by the database directive does not apply to databases containing data obtained from or generated by the use of a product or a related service. Okay, so in other words, it seems from this provision that the sui generis right doesn't apply to machine data. So if you have a kind of an IoT or other forms of fourth industrial revolution product, you shouldn't be allowed to own that data by means of the sui generis right, which seems amazing. But then if we find the recital 84, which is a masterclass in how not to write law. I mean, I cannot even read it. If you try and read it, you cannot, because it's too long to be read without breathing. But the sort of the core of this recital is that well, I'm going to read the part that is important. The sui generis right, where such databases do not qualify for the sui generis right, and in so doing hinder the effective exercise of the right of users to access blah, 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 does not apply to such databases as the requirements for protection would not be fulfilled. I'm going to leave you maybe 2 seconds with it because it's a lot. Yeah, I would need 3 or 4 hours to unpack that, but we don't have it. I know you would love it, but probably the main issue there is that, well, main issue probably is the where, understanding the meaning of where there. It's not clear if it are all sort of smart sort of IoT produced databases excluded from protection, or only where those databases that do not qualify because one of the requirements don't apply and that hinder the effective exercise of the rights of users. In other words, is where such databases do not qualify for the sui generis right, is it a fact or a normative statement? So we have 2 possible interpretations of this recital. One is that databases made of data obtained and created by connected products are not protected by the sui generis right, and probably that's what they had in mind, I don't know. Or that if the data can be said to be obtained, not created, but obtained by connected products, then the sui generis right can still apply. Remember the jurisprudence that I mentioned before between created data and obtained data. If data is obtained, still the sui generis right can apply. So I thought, let's have a look at the different translations of the Act, because often translations can help us understand what where means. And we have in French, it means whereas, it's translated as whereas, in German as although, and Italian it's in the event that, and in Spanish when. So you can see how essentially in every language it's translated as something different that seems stupid, but actually means something really different. So we could, again, both of those interpretations that I suggested before could be justified depending on what we mean by when. So what it seems that's happened there is that maybe the sort of the solution to the problem, according to the European Commission, is to get rid of that dichotomy between obtaining and creating data and creating a new dichotomy, because dichotomies work very well. And so the new dichotomy is, on the one hand, data that is obtained, generated, or collected by IoT devices. That's on the one hand, and that's covered by the Data Act. And on the other hand, we have inferred or derived data that is not covered by the Data Act. So it would seem that maybe what they mean is that essentially all databases are not, all machine-generated databases are not protected by the sui generis Act, except perhaps databases with inferred or derived data. That's a possible interpretation. Why do we exclude inferred or derived data that we know? Obviously there is the famous Sandra Wachter paper about inferred data. There is a lot now of literature around the importance of inferred or derived data. So, you you may wonder, why do we need to exclude it from the Data Act? It's not clear. I mean, the justifications that the European Commission gives are nonsense, so I'm not going to go through them. But okay, so we have all this confusion. We really still don't know essentially when the data can be owned and controlled when generated by smart devices or not. And that's a big problem, linking back to what I mentioned before, the private ordering, so the use of technologies and contracts to control and own data generated by machines. Now, the Data Act is partly aware of the problem. So you will find, for example, Article 11, whereby technical protection measures shall not be used to hinder the user's right to provide data to third parties. So we know at least that one of the rights provided by in the Data Act prevails on technological measures. What about all the other rights? What about this sui generis right? It's not something that is clear. When it comes to contractual control over data, and that's the last slide for the conclusion, again, the Data Act is aware that it's a problem, that companies use the terms and conditions to prevail, to control data, to prevail on the law. So the Article 12 of the Data Act provides that any contractual term in a data sharing agreement, which is to the detriment, which excludes the application of this chapter, shall not be binding. Okay, but it doesn't clarify what happens to the obligations and the rights that are not provided in that specific chapter of the Data Act. So does it mean that terms and conditions can be used to prevail on all the other protections that we have? And this is even a more pressing problem, because Article 35, there is the article about the database right, is not imperative, doesn't clarify that prevails on technological measures and contracts. So to conclude, this is obviously partly also some form of research agenda, or a call for a research agenda in innovation law studies, to try and contribute more to the idea of sustainability and data sustainability. I think we have something to say, and I think we should say it. Despite a number of laws and the European data strategy and national laws as well that claim that are doing something to improve access and reuse of data, I think there are still insufficient incentives for private companies to open up their data. There are still all these data enclosures, and I think we should do something about it. The Data Act, despite being a masterclass in how not to write the law, is an overall step in the right direction, but we need to clarify a lot of points, and I mentioned a couple in my presentation. Mainly, I think, really clarify which databases are excluded and which databases are included. Are we proposing new dichotomies that are going to be disrupted by the Internet of Things? And again, more clarity around private ordering. How can we prevent private companies from using terms and conditions and technologies to prevail on our rights? Thank you.